a walkthrough of California Form FL-115, the document that proves the respondent was properly served with the summons and petition, including who can serve papers, methods of service, and why filing it matters. What is Form FL-115? Form FL-115 is the California Judicial Council form titled Proof of Service of Summons. It is a sworn statement completed and signed under penalty of perjury by the person who delivered the divorce papers, confirming that service actually happened and describing exactly how. Once the summons FL-110 and petition FL-100 are filed, they still have to be delivered to the respondent before the case can proceed. FL-115 is the record the court relies on to confirm that delivery met California's legal requirements. Without it, the court has no verified way to know the respondent was ever notified. Who can serve the papers and who cannot? Service rules in California are strict about who is allowed to hand over the papers. The person who serves the summons and petition must be at least 18 years old, not a party to the case. That second requirement matters more than people expect. The petitioner, the person who filed the case, can never serve their own papers, no matter how straightforward or amicable the situation is. The reasoning is simple. The court needs an independent, neutral confirmation that service happened, and a party to the case cannot provide that. Eligible servers commonly include a friend, an adult family member who is not part of the case, a co-worker, or a professional process server. What documents must be served? The respondent generally must receive copies, not originals, of everything that has been filed so far, most commonly the summons, FL-110, the petition, FL-100, a blank response form, FL-120, so the respondent has what they need to reply. Any UCCJEA declaration, if minor children are involved, any other paperwork filed alongside the petition, such as a request for a fee waiver. Form FL-115 asks the server to identify exactly which documents were delivered. This list should match what was actually filed with the court. Leaving out a document or serving an outdated version of one can create problems later if the respondent challenges whether they received proper notice. Methods of service. California recognizes a few valid ways to serve divorce papers, and FL-115 asks the server to specify which one was used. Each method has its own procedural requirements, and substituted service in particular has specific follow-up steps, including additional mailing, that must be completed correctly for service to be valid. If there is any doubt about which method applies to your situation, confirm the requirements with your County Superior Court Self-Help Center before proceeding. Completing Form FL-115 section by section, here is what the server actually fills in. Case information. The top of the form identifies the county, the case number, and the names of the petitioner and respondent, matching what appears on the petition and summons already on file. Who was served? The server states the full legal name of the person served. If service was substituted, this section also identifies the responsible adult who accepted the documents on the respondent's behalf. What was served? The server checks or lists which documents were delivered, matching them against what was actually filed with the court. Date. Time and place of service. This is one of the most important sections on the form. The server records the exact date service occurred, along with the time and location, a home address, workplace, or other location where the delivery happened. The date recorded here is not a formality. It is the date California's mandatory 6-month waiting period begins, so it must be accurate and match the server's own recollection or notes. Method of service. The server indicates whether service was personal, substituted, or by mail with a notice and acknowledgement of receipt, and completes any additional details required for that specific method. Server's information and signature. The server prints their name, address, and, if applicable, registration information for a professional process server, then signs the form under penalty of perjury, confirming that everything stated is true. Why the service date starts the 6-month clock. California requires a mandatory 6-month waiting period before a dissolution can be finalized, and that clock starts on the date of service, not the date the petition was filed. This is a detail people frequently misunderstand. Filing the petition early does not shorten the waiting period. The waiting period cannot begin until the respondent has actually been served, and that service has been documented on a filed FL-115. A delay in serving the respondent, or a proof of service that is filed late, pushes back the earliest possible date the case can be finalized. Common mistakes to avoid: trying to serve your own papers as the petitioner, which makes the service invalid; recording an incorrect or approximate service date instead of the exact date service occurred; choosing the wrong method of service for the situation, such as attempting substituted service without completing the required follow-up mailing; leaving out a document that was actually served or listing one that wasn't; forgetting to have the server sign the form under penalty of perjury; never filing the completed proof of service, which leaves the court without evidence that service happened at all. Filing the completed proof of service. Once the server has completed and signed Form FL-115, it has to be filed with the same superior court where the case is pending. This step is easy to overlook since it happens after the more visible steps of filing and serving, but the case cannot progress without it. Until FL-115 is on file, the court has no verified record that the respondent was notified of the case. The 30-day period for the respondent to file a response has not been established. The mandatory 6-month waiting period is not considered to have started. The case cannot move toward a default judgment if the respondent does not respond, or toward finalization once both sides are ready. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-115 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.